Well, good morning, everyone. Glad to have you here. I'm Beth Chandler, President and CEO of YW Boston, and our work focuses on helping organizations create more inclusive environments so that women, people of color, and especially women of color can thrive. In this climate of, and again, want to thank you for joining, just so you know where you are. This is Navigating DEI Challenges, Legal Insights for Moving Forward in the Face of Resistance. And in this climate of organized backlash against efforts to build more diverse, inclusive, and equitable organizations, YW Boston sees an opportunity for all of us to think about and practice courage. Today's webinar is designed to help us move past the news headlines and take a clear-eyed look at the current legal landscape so we have a better understanding as to how to continue to push DEI efforts forward and how we can remain steadfast, strategic, and deliberate in these turbulent times. We're bolstered by how many of you wanted to join us today and are here to participate, and we hope that you'll take back things from this conversation to help you continue to move forward in your work in the days and months ahead. Our agenda today is that Chris Hart and Rosa Nuñez, who I will introduce in a second, are going to provide us with an overview of what's happening in the legal environment. During this time, please feel free to put questions that you have in the Q&A section of the Zoom, and then we will come back after around 9:55 to have a couple of questions that I'll pose to Chris and Rosa, and then to answer your questions. And then it will close at about 10:25 and get you out of here by 10:30. So that's our agenda for our time together. And then I just want to introduce our speakers for today. We are thrilled to have Chris Escobedo Hart and Rosa Nuñez join us from the firm of Foley Hoag. Chris Hart is an experienced civil litigator and human rights lawyer with a focus on cybersecurity and global data protection. And Chris is also on our board. And Rosa Nuñez is Chief Diversity, Equity, and Inclusion Officer at the firm. And in her role, Rosa is responsible for developing, implementing, leading, and championing proactive diversity, equity, and inclusion initiatives and programs in alignment with Foley Hoag's overall strategic plans. So Chris and Rosa, thank you so much for joining us this morning, and I will turn things over to you.
Beth, thank you very much. It's a real pleasure to be here. Really appreciate the invitation, and I'm thrilled to be here with Rosa. We work together a lot on these issues, and we're very happy to be presenting to this audience. And I will say, although I do wear a cybersecurity hat, I promise there will be no cybersecurity discussions in this presentation. I work with Rosa in part as well on our DE&I efforts. In representing clients, and so some of what you'll hear from us will be not only our understanding of the current legal landscape, but also how we approach clients. So I'm going to kick us off, and although we have a number of presentations that we're going to be going back and forth about, we will probably, Rosa and I, be asking each other questions. We're chiming in from time to time, and we'll try to keep it interesting for everybody.
We promise it's going to be interesting and worth your while. Maybe like a little bit of a comedy show, but in all seriousness.
We will definitely keep it interesting. So here's what we're going to talk about. Well, I'm going to spend a little bit of time just talking about the legal landscape in the aftermath of last year's admissions decisions. Talk about what corporate leaders, what business leaders, what essentially everybody outside of the admission space needs to be thinking about, what some of the responses to the decision have been from a legal and political perspective, and then talk about what best practices are. Although the recommendations and best practices we'll talk about at the end, you'll see that they're sort of interspersed as we go. Okay, so a little bit of background. I'm sure many of you are already quite familiar with the admissions decision, but just to do some table setting. In June of last year, the Supreme Court decided Students for Fair Admissions versus Harvard and versus the University of North Carolina. And both, what the court found was that both of the admissions policies violated either the Equal Protection Clause of the 14th Amendment to the U.S. Constitution or Title VI of the Civil Rights Act. it was a 6-3 decision. Remember, there's a conservative supermajority on the court. It was a decision signed by Chief Justice Roberts, and there were a number of concurrences and a couple of dissents. And one concurrence in particular has a lot of importance to what we're going to be talking about. So what did the majority opinion say? So first, there's a problem with the goal of these admissions policies. So according to the court, student body diversity was not sufficiently measurable to qualify as a compelling interest to justify race-based policy. So in the law, under constitutional analysis, this idea of a compelling interest is what the state normally has to show, or what the entity usually has to show in order to overcome a constitutional hurdle. And here is saying it just simply wasn't as articulated. So even though student body diversity is commendable and worthy, it is standardless, and my favorite phrase, inescapably imponderable. So it's already well known that using metrics to try to match population diversity would be an unconstitutional racial balancing. So you would think that if on the one hand this is too abstract to be useful, on the other hand maybe we just need more data, but that's already something that the court has said is forbidden. And so because of this inescapably imponderable, standardless goal of student body diversity, there's no logical way to find an endpoint or to meet the goal. So that's the problem with the goal. There's also a problem with the means of achieving that goal. And what the court reasoned was that admissions programs lack a meaningful connection between the means they employ and the goals they pursue. And they criticize racial categories used by universities as imprecise. So, for example, Asian or Hispanic as categories for purposes of admission. The other thing that the court observed is that college admissions are zero-sum. So by offering benefits to some applicants on the basis of race, schools end up using race as a negative for others. You can't give everybody a slot. And then finally, the court recognized that there was an inherent benefit in race, qua race, so race in and of itself, and that is, according to the court, racial stereotyping. So that's the majority opinion in a nutshell. But what didn't it prohibit? So what the court said was that universities can define their missions as they see fit. There could be exemptions in military academies. There have been lawsuits, although yesterday the court declined to hear a case arising out of a Virginia academy. Critical mass programs, like in the University of Texas system, their 10% rule, they're still fine. And that's 10%. We'll take the top 10% of schools within the state. What the court also said was nothing in the opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affects his or her life, be it through discrimination, inspiration, or otherwise. But universities are not may not simply establish through application essays or other means the regime that the court holds unlawful. In other words, what the court is saying, you can look at somebody holistically, but you can't use these essays or other admissions tools in order to do an end run around our decision. It didn't. The decision didn't cover recruitment efforts. It didn't cover activities to increase yield in admissions. It didn't affect scholarships. It didn't affect data collection. It's really important for the remainder of our discussion. It didn't affect race-neutral strategies, DE&I programming within schools, or employment-based affirmative action programs. So the DE&I and employment legal landscape out of the Supreme Court decision remains unchanged.
And if I may add, Chris, we as practitioners, so Chris is here more from like the legal perspective, right? Kind of like to help us understand what this means and it doesn't, right? And I'm here as a practitioner, right? Someone that is down in the trenches, really trying to push initiatives that sometimes are a little risque. But then I rely on people like Chris to kind of like slow me down. But like, what does this really mean for someone that is doing this work? in your organization. And in anticipation to the decision, we were expecting the worst, right, Chris? We thought that race and gender and affirmative action was going to be completely banned from any discussions in higher education admissions, but they actually left the door open. So if there's any good news out of what happened is that there is still opportunities for someone to demonstrate their candidacy and why they're the best to join that organization or that higher education or entity based on their life stories and their personal stories and history, right, Chris? Like that door is still open.
That's right. And in fact, I think this is the questions and answers in this slide, I think are exactly the kinds of questions that you and I would be talking about in advising a client. So how should an organization be thinking about equity initiatives in light of the decision? Yeah.
Yeah,
So that's
I agree.
Yeah.
I agree. Like, yeah, this is a really good question. So from a D&I perspective, you know, what we're seeing is that D&I work, as you all know, is being politicized, it's being scrutinized, it has been polarizing, right? Every day, especially practitioners will feel that we are a little bit more under pressure, that our job that has never been easy is becoming sometimes unbearable and very difficult. But the work is worth doing. That's all I'm gonna say here. And you'll hear that a lot of the things that we are doing in organizations is completely legal. So we're gonna talk a lot more about more about that later. But looking at this question, you know, what we fear is that when the right case reaches the court, and the same justices who endorsed the colorblind, that's how I call it, like a colorblind admissions policy approach to higher education, see it could also hold it to private employers. So there is a possibility that, you'll see it in the presentation, a lot of litigation started to pop up targeting employer diversity, equity, and inclusion efforts. So when we look at, you know, this question, how should our organizations, right, be thinking about our equity, and I also call it diversity and inclusion initiatives in light of this decision, is, you know, to think about the why. You know, missions are permissible. Why do you want to focus on diversity, equity, and inclusion in your organization? Is it part of your culture? Is it part of your mission? You know, is it because you know and understand the war on talent? Like, you have to have a why and tie it to your business, to your bottom line, right? Your mission is still permissible. You can still have goals. You can still have a statement of D&I that it is crafted in the right way, right? Data collection is also permissible for the purposes of understanding trends. You can still collect all of the EEOC data and voluntarily share information such as LGBTQ status, persons with disabilities, right? Veteran status. Like, you can still collect that and track that in order to know where you're going. What we are not supposed to be doing, and never, I think, Chris, we were able to do, is set hard quotas or goals, because you then are at risk of being a target, right, Chris? Can you jump on that a little bit?
No, that's right. I mean, and I think that the next couple slides are going to get into this a little bit, but I think in some ways what the decision has forced is not having organizations end their programs, which I think has been a big concern, but readjust the perspective and language of their programs. So you see in this slide, right? This is about how are you articulating your mission? How are you articulating a mission so that you can achieve the same goal without running into some of the traps that the admissions decision suggests exist? You know, what are you doing with data? You can still collect it and you can still use it, but how are you using it? I think is different. So, and one thing that Rosa said, and I want to make this clear to everybody, is that you know, sometimes I think lawyers, Rosa, I think sometimes we get a bad rap for saying no, but I think in fact, what I want to say is do not back down from your
There you go.
DEI goals. It's a question of finding a way to make it work in the current environment.
I totally agree with that. And, you know, something that I will say is the key to the work that you're doing, and we're going to talk about it later, is making sure that everything that you do, again, goes back to your why and it benefits everyone, right? Giving an opportunity, especially in the workplace setting, to someone solely because of their gender or race or any other protected class, it is still like it's always been illegal, right, Chris? Like this is not something new. But there's many organizations that got away with it in some ways. It's just thinking about how you do this work in a meaningful, holistic way. So if you look at the last bullet point, like remedying identified disparities and that historically has happened. Like for example, in the legal industry, this has been an industry that has been segregated for a long time. It was an industry that it was not very friendly. And I'm just going to be very generous. 20 years ago, to people that look like me, attorneys of color, right? Attorneys from underrepresented backgrounds, women. And there has been a lot of efforts in the past 20 years to revert that. You know, there has been a lot of financial commitments with law firms really working with higher education organizations, creating fellowships to kind of help provide access. All of that continues to uphold the law, right? But how you do it is the key. And I'm going to pass it over to you, Chris.
Yeah, and I think that's a good segue to thinking about the direct application of the admissions decision and what the fallout has been on non-educational organizations. So in terms of the direct impact, you know, one of the expectations is that student body diversity is going to likely decrease. Competitive and in-demand schools are likely going to be impacted the hardest and likely experience a decrease in diversity. I mean, this is still playing itself out. So, and there are still lawsuits. But it's clear that there's no substitute for taking race into account when attempting to increase diversity. So, for example, diversity fell significantly at the University of California and Michigan schools despite race-neutral measures, and has only seen a modest return despite significant financial investment in DEI. So this is going to have, it's starting to have and will continue to have a significant effect. And obviously what happens in our educational institutions will affect organizations and the economy as a whole over time. And eliminating race-conscious admissions practices will also meaningfully reduce the overall a number of underrepresented students who apply to college. So this will absolutely have ripple effects throughout the economy and throughout educational institutions. But here's where I think things are really important for organizations to consider, and that is the observation made by Justice Gorsuch in his concurrence. And that's essentially, I won't read this whole quote, but it's essentially this: Title VI, which pertains to admissions, and Title VII, which pertains to employers, have the same language. And if they have the same language, then the analysis is going to be the same. And so if and when a Title VII case comes to the court challenging organizational DE&I programs, I think we have to assume that we're going to see much of the same kind of analysis come from the court. And if that's the case, then I think we need to start thinking, and as we've already started to say in this presentation, about how what the court has said will impact what pretty much any organization can do, and how organizations should be thinking about not only what they can do now, but how to, you know, for lack of a better term, future-proof their DE&I programs. So just quickly, I just want to talk a little bit about some of the responses to the decision already. And many of you might be familiar with this, but I think it's an important reminder. So first, coming out of the decision, 13 state attorney general's offices sent letters to Fortune 100 companies. You can see the list of states here. Essentially, it's a shot across the bow. That they're saying that Fortune 100 companies need to focus on scaling back their racial preferences and quotas. That's the language from the letter in their hiring practices. Senator Tom Cotton from Arkansas sent a letter to law firms singling out firms that have, quote, adopted race-based hiring quotas and benchmarks as part of their DE&I initiatives. Now, one of the important things to say here is that these letters don't say anything new about the law. They didn't create new laws. They didn't say that there was anything new about how laws should be interpreted, because, as Rosa was saying, race-based hiring and promotion decisions have always been prohibited under Title VII. But what's happened now, as we've seen and as we're going to continue to see, is that there's going to be, and there has been, increased enforcement in this area, especially when companies make quota or other goal-based statements about hiring practices. But more than that, there's just increased hostility. I mean, from my perspective, and I think the perspective of probably all of you listening to this, the admissions decision was a truly sort of emboldening moment for lawmakers, policymakers, activists who are hostile to DEI programs. And some of you may have read it in the New York Times a few weeks ago. There was a very lengthy article about the activist and intellectual background that has led to the moment that we're in, where there's been a very, very deep hostility toward DE&I, toward anything having to do with diversity initiatives, and sort of for mixed reasons. Many of them, some of them ideological, some of them purely political. But now we're seeing sort of a lot of energy, money, and resources put into trying to push the envelope even further to challenge these programs. And we've also seen some attempts at anti-DEI legislation. So model language was drafted earlier last year, not this year, by the Goldwater and Manhattan Institutes. There were 40 bills that were introduced, 29 were tabled or failed to pass or were vetoed, but 7 became law. They apply to public higher ed institutions. They mostly restrict the use of diversity statements, diversity oaths, mandatory DEI training. But Florida and Texas passed more expansive laws restricting DEI funding and programming. So I think all of that is just, it's really important to understand that the admissions decision isn't just about universities. It is, but it isn't. We can expect that the court or courts, if they're forced to apply the admissions decision in the Title VII context, are going to come out in largely the same way. And there are a lot of hostile efforts by legislators and policymakers regarding DEI programs. So Rosa, I'm curious to know from your perspective, given the hostile environment, we've talked a little bit about reassuring organizations that there are paths forward. But from your perspective, like what's the biggest thing that you think organizations can really start thinking about in terms of making sure that they're not going to fall behind in, let's say, recruiting efforts or promotion efforts or retention efforts when it comes to DEI programs?
Well, thank you, Chris. And I will say, 3 years ago, like most of you on this call experience, many organizations, large and small, after the killing of George Floyd, Breonna Taylor, the rebirth of the Black Lives Matter movement, remember the marches and the protests, many organizations that we all know of jumped right in and started pledging and started, voicing their commitment to DE&I. They hashtag this and hashtag that on social media and LinkedIn. They created DE&I departments. They hired their first DE&I, either chief or professional, because at that moment, they really thought it was important. Not before, but at that moment. So unfortunately, because of all this commotion and this noise and misinformation that is happening, right? Oh, I don't know what DE&I is, but I don't like it. And I'm going to go ahead and protest against it. Many organizations that were never in the first place doing this for the right reasons are now using this noise and this scrutiny to back down. Not only to back down from their efforts, but also to close down their DEI offices, lay off professionals, right? Just because, this is not legal anymore. And maybe we just don't want to do that anymore. So that aside, right, Chris, the organizations that have been doing D&I work for a long time, or that just started but are doing it for the right reasons, right? Because of the why, because they really understand the importance of diversity, equity, and inclusion, and the benefit to everyone, not just a particular group, but to everyone. Should start thinking about, look at how you're doing your work. There's a lot of what I see. People ask me, do you think D&I is dead? I'm like, D&I has just begun, because the focus is the benefit of everyone. And when you think about the three areas of work that we do holistically as practitioners, right? We work about debiasing. Our work, most of it, focuses on debiasing the workforce, right? Looking at ways to remove barriers and microaggressions and biases in recruiting and promotion, right? And performance reviews, and the way that we conduct our business and clients. And like it or not, unconscious bias training kind of go at the core. The benefit is that it tries to debias the workforce. And that is pretty much aligned with the colorblind approach that the core took, right, Chris? Like, there's nothing wrong with doing unconscious bias work and working in your organizations to remove barriers that have prevented underrepresented communities and others from having full access to your workforce. Another thing that we continue to work on, and that is not going to go anywhere, is how D&I enhances your culture, right? So when you work on creating spaces for people to feel safe, right? Are you creating an environment where folks can feel that they belong in your organization, regardless of who they are, right? Creating safe spaces such as affinity groups, with a caveat that I'm going to talk about later. Doing recruiting practices that attract, very specific recruiting practices that attract the organizations that you want to target. So, for example, creating partnerships with historical Black colleges and universities. Like, there's nothing wrong with doing that, and continuing to do that to enhance the culture and the diversity of your workforce, if this is part of your mission and your why. And also, the third thing that we focus on a lot is creating an environment where everyone benefits, right? The universal approach to D&I, what it's all about. It's all about inclusion and belonging. You're going to continue to do inclusion and belonging work, and that's also aligned with a colorblind approach that the core has adopted. There's nothing wrong with creating policies and practices that welcome everyone, right, into your workforce, like creating flexible work arrangements for people with disabilities, for example, having mothers and rooms for moms to use during the day, creating policies and practices that create psychological safety, right? So those things are the core and the meat of the work that we do, and they're still pretty aligned with the approach that the core took. So, Chris, what do you think about that?
I hope that people who are listening can hear that there's good and bad here, right? That there are a lot more restrictive guardrails that I think organizations need to be careful about, and I'm gonna go into some other legal issues here in a moment. But that there are ways to thread the needle, and to continue to try to be successful in DE&I efforts. But there's just no two ways about it. It's harder.
It's harder.
It's harder now than it was. Let me take a couple go through a couple more slides to talk about some of the legal fallout here, and then talk a little bit more about best practices. So, or emerging best practices. So one question that we often receive is what kind of claims are actually being brought after the admissions decision against private employers. And I have here 42 USC 1981. This is actually out of the Reconstruction, the Civil Rights Act of 1866, and you heard that correct, 1866, a Reconstruction era civil rights law that was supposed to end discrimination in contracting. But what it's being used for now is to challenge contracting programs or supplier diversity programs, or supplier diversity, pipeline diversity in contracting, or contracting with disadvantaged businesses or minority-owned businesses. So, frankly, perversely, it's being used to make it more difficult for those kinds of programs. There are a few elements here, like I'm just going to gloss over that. The law states that all persons shall have the same right to make and enforce contracts as enjoyed by white citizens, right? So this is the Reconstruction era issue. But several courts, including the Supreme Court, have interpreted it to be applicable to racial discrimination against white persons, so-called reverse discrimination claims, as far back as the 1970s. And any exchange of consideration is really just a technical term to say, any kind of ordinary quid pro quo in a contract can create a contract under that is challengeable under this law. So how is it being used? So it's been used to challenge law firm DEI practices. So there were a couple of lawsuits brought against two very large law firms, Perkins Coie and Morrison Forrester. They targeted diversity fellowship programs and hiring programs that had race-based eligibility criteria. And diversity fellowships are very common programs that are used by law firms to help increase diversity in the pipeline of law students. And rather than challenge or defend against the lawsuits, both the law firms changed their criteria. And then the lawsuits were dropped. So, clearly it had an effect. The law firms didn't want to have those challenged and make bad law. And so they simply changed their programs.
May I add here, Chris? I'm sorry to interrupt you, but for those of us that are practitioners, this is why law firms are very risk adverse. So lawyers tend to advise people not to take too many risks. But I will say that, it worked, but it didn't change the outcome, right, Chris, of the purpose of the fellowship.
That's right. Although I will say that there's a certain chilling effect that's happening with these lawsuits, where for example, just this next example is the lawsuit against the Fearless Fund, which has been going. It's ongoing. Many of you probably know what the Fearless Fund is. It's a minority, a Black woman-owned venture capital fund that provides venture capital money to I believe minority women-owned businesses. And it's been challenged under essentially the submissions theory and Section 1981. And what's happened to the organization is that it's had to spend so many resources. In fact, it was enjoined from providing grants, that it's put the organization on the brink. Right? It makes it really difficult for organizations to actually operate in this kind of environment when they're being sued. And where other organizations might otherwise want to be providing grant monies or venture capital money, whatever the case may be, or let's say hiring associates who are diverse, the kind of chilling effect that we're talking about is real and it's intended, right? So I think the kind of effect that we'll have, let's say, on law firms, challenges these kinds of programs, I think, it's going to play itself out over time. Whether there are ways to pivot, and I already see some questions in the chat about how we can do that. There are ways to pivot, but how successful that pivoting is going to be, I think, is going to be a story that is going to be told over time, and might involve a lot of iteration, I think, to get to the right spot. Rosa, did I answer your question?
Yes, thank you, Chris.
Yeah, sure. So we talked about the Fearless Fund as well as Hello Alice lawsuit. So grant programs are being challenged, and then the American Alliance for Equal Rights, their mission is to expand the reach of this Reconstruction era civil rights law and make it applicable in all contractual contexts. And then American First Legal is an organization run by Stephen Miller of the Trump administration fame, who's really working. I think these organizations are really working to undo a lot of these kinds of grant programs and DE&I programs. And then also with disadvantaged business enterprises, there's been movement here as well. So one case out of Tennessee struck down a provision of the Small Business Act that equated race with social disadvantage. So business owners have to submit an essay demonstrating that race has hindered their success. And then out of Kentucky, there was a case regarding disadvantaged business enterprise programs where federal government finances the American transportation system, like highway construction, with a series of, as the court put it, race and gender preferences called goals. But from the court's perspective, the goals were discriminatory barriers, and they prevented construction companies from competing. This is essentially a reverse discrimination lawsuit. So this is how we're seeing these kinds of cases play out. And I think Rosa, I'm gonna turn it over to you from here on.
That sounds great, Chris. And I will say, again, what we want to remind everyone is that the decision is isolated to the higher education environment right now, right? You can continue to double down, because that's what I'm going to say here, double down on your D&I efforts. Now be mindful that you have an army of individuals like the ones that Chris just mentioned that have made it their mission to make diversity, equity, and inclusion across the country and every single sector and every single aspect of society illegal. So I want you to really think about that, right? They started with higher education because race and gender were used as a plus. When all things being equal, can we say we want to admit this person over this, right? It was an easier way of having a win, and it wasn't overnight either. Now they're going to go after the most significant target, which is workforce, right? Because workforce and employment and access to opportunities changes generations and impacts the way that generations function. So I want you to be mindful of that. So you're going to continue to double down and do your work and focus on D&I, but you have to be smart about it. You have to get some guidance on what's permissible or not to be able to proceed, to succeed and your goals and what your organization is doing. So some of the trends that we're seeing, right? I mean, take a look at the slide right here. There's a lot of noise, a lot of misinformation, a lot of fear. And in particular, if your organization, and not anyone here, but organizations that were not doing D&I work for the right reasons, they're finding a way out. And unfortunately, it is costing not only their employees, but also the clients that they're serving. Can we go to the next slide, Chris, please? So most obvious potential risk, I mean, for like Chris was saying, and in the legal industry, the law firms were quick to respond, right? Because we are as nature very risk adverse, but there's a lot of risk for employers moving forward because of how much funding and effort is being put on weaponizing DE&I. So think about your efforts and your initiatives in your organizations and identify any instances where you are guaranteeing or providing a benefit to a group of individuals over others. This is what is called the zero sum, right? That the core evaluated, and which means there's no gain. Either you win or you lose. If you didn't get access to this, you lose, right? So you are in deficit. So think about any areas in your workforce where you are providing an advantage to a group that causes an automatic disadvantage to another group, right? Another thing that you should be looking at is also in your organizations, any situation where someone or a group of people is denied participation of a benefit, of receiving a benefit. So when we talk about, for example, creating affinity groups, that is the best practice. It is a great way of creating a sense of belonging, of creating a space for people that have the same affinities and the same values and backgrounds to come together, right, and gather and share experiences. But are you opening it up to allies? Are you opening it up broader so people can, if they want, also join the Black affinity group because they care? For example, I know it's not ideal, and I'm going to hear in the comments, but those are the things, believe me, but those are the things that you need to be thinking about in order to make your DEI efforts what I call it bulletproof, right? Is there an opportunity for others to take part, even if you know they're not going to join that affinity group? But there's no one can say, well, I was prevented from joining the affinity group, and they don't know my story, they don't know my background, right? Also, another thing that you should think about is, are you publishing your DEI goals, or are you publishing DEI targets? So for example, I started my DEI career in the consulting and management consulting industry. And in management consulting, they love to have very aggressive goals, right? By 2050, we're going to have 30% of women engineers, for example. But how are you going to get there? You're going to open the door to a lot of scrutiny if you don't have very clear guidelines. You better have a very clear pipeline development program in order for you to sustain or to defend how you're going to get to your 30% by 2050. It cannot be a very ambiguous kind of goal, because it can be a target for litigation. Is that right, Chris? Because you are the attorney here.
So I think yes. Let me I'll answer your question directly.
Yes.
But let me give I think my gloss on this, which is and I see already some of the questions in the chat along these lines. The way that organizations need to be thinking about their overall goals and strategies as it relates to DE&I is thinking about them in terms of values, right? What is the organization's value? What are the values that we're trying to that we're trying to create in the organization? And it's the difference between saying, we want to hire XYZ kinds of people in our organization versus, we want to have an inclusive right. an inclusive and diverse environment so that we can, et cetera. We can have a reflection of the best ideas in the industry, or wherever the case may be, and then it's then the question is, how can you achieve DEI goals with those kinds of frankly somewhat more amorphous values, or at least values that can go to a lot of different things. And I think that's where data comes in, right? Where it's okay to maintain data on what, who you're hiring and what that demographics looks like and whether there's a mismatch, right? Correct. And if it turns out that, your workforce is looking less diverse, then it's a question of, how do we have to tweak these values that we're articulating, or how do we have to think about whether the people that we're attracting and that we're hiring match up with those values. Now, look, it's kind of a clumsy thing to do compared to a much more straightforward way, I think, of increasing diversity in an organization. But that's essentially where we are. And Rosa, if I could just say one other thing, because I'm a lawyer, I need to say it, but I think it's really important. A lot of this has to do with risk appetite, right?
Right.
We've just gone over a number of letters from Tom Cotton and letters from AG's offices and hostile legislation and hostile litigation, and all of that presents risk. But some organizations might have more risk appetite than others, and might be more willing to take certain risks with regard to their hiring practices, their supplier diversity. So, for example, I've been representing a large organization that had a supplier diversity program that raised some red flags under the current environment. So and it's not unusual to have they had a contract with another organization where there were percentages of targeted the number of minority-owned businesses they wanted to have in their supply chain. Right, I'm being abstract because I have to make sure it's confidential and privileged. And an organization really can't do that under the current environment, and probably could never do that. But then it's a question of, well, how do you tweak that, and when do you tweak that? And part of it is, to what extent are you willing to take the risk that it could be challenged? And so my advice as a lawyer is, like, you want to minimize this risk by either amending the contract or by amending the contract. But an organization might decide, you know what, we're actually we're gonna either amend it in a very slight way, or we're going to keep it for now and see what happens. And that's fine, as long as they understand, like, that they could be subject to a lawsuit. So, I think it's that kind of sort of understanding what the environment is, what industry you're in, how big an industry you're in, where the risks come in, that you can then decide how you want to alter your programs.
Thank you, Chris. Thank you. No, that's perfect. And that goes to our last bullet point that talks about, decisions made solely on race or gender or any kind of protected class. Like, you have to really think about, just take a step back and say, what is it that I'm doing that is disadvantaging a population, and can I modify that so I am not targeted, and I want to continue, if I want to continue doing my work in a meaningful way. Can we move to the next one, please, Chris? So recommendations, right? So Rosa, Chris, you talked all this legal jargon and all these things and all these fears, but what is it that we can do for those of us that are here, that this is something that is critical to our work, that we care about, that we value, and that our organizations are fully invested? One of the first thing that I want to say, and is more holistic, right? Because we all need the talent in our organizations, we all need the pipeline, is to continue to encourage kids from underrepresented backgrounds to apply to higher ed institutions, to the elite institutions, to the top 10 institutions, because before the decision, kids from underrepresented backgrounds, especially those of first generation college students, were not motivated to apply to higher education institutions because of fear of not belonging, because of fear of not deserving it, because of financial reasons, you name it, right? I would say that now more than ever, we need to push our kids to pursue their dreams and to go and apply, because they can still talk about how their background and their journeys and their race and their gender have influenced them to make them the best possible candidate for that school. The concept of colorblind, and I saw a comment in the chat, is outrageous to me, because if you don't see color, you don't see me, you don't see my story, you don't see my immigrant journey. You don't see me coming into the States as an immigrant at 18 and trying to figure everything out by myself, right? You don't see who I am. But there's an opportunity where I can now, as a student, add that into my story, right? Without the school having to decide just solely on my race or gender, but I can still talk about it. So please, let's continue to encourage and invest on the future pipeline. Now is not the time to discourage kids. Now is the time to empower them to continue to pursue their dreams. Again, I will say, continue to focus your D&I efforts within the 3 categories that I gave you. which is breaking barriers, right? Education around biases, microaggressions, looking for equity, making sure that your policies provide equal and equitable access to everyone, the way that you conduct business, the way that you hire, the way that you attract, the way that you promote folks. Look at that, look at those processes to make sure that they're fair and that they're equitable. You can still continue to work with external partners to achieve your DE&I goals and objectives and your mission. If your mission is to have an environment that is diverse, that is innovative, that it is an environment that is representative of, I don't know, the cities that you live in, you can continue to work with organizations that their sole purpose is to advance diversity, equity, and inclusion in your industry. There's nothing wrong with targeting colleges and universities that are the most diverse if they have students that will fit your needs, right? There's nothing wrong with doing that. But again, it's all about providing the opportunity to the right person. Looking at, what is it that you're doing that will prevent folks from accessing your workplace? So for example, continuing to review your job description, making sure that they're not biased, that you're removing anything, any indications of someone being disqualified. People of color and women, we tend to disqualify ourselves even before we put in the application or the resume. So how can you make it easier for folks to kind of put their name on the hat, right? If you're trying to attract more diverse candidates. And again, if there's a message that I want you to walk away from this conversation today, is that you don't need to back down. If you're doing this for the right reasons, you don't need to back down. You just need the guidance to make sure that what you're doing is bulletproof. Next. So Chris, question 3, common question that we get. What can employers do to protect themselves from such claims while maintaining the integrity of their D&I efforts? And before you answer, I want to kick you off with saying it is very rarely, although they try, for a disgruntled employee to say, oh, I am just going to put a lawsuit or a claim because I don't like their Women's History Month programming, or I am upset that they are, that they have a D&I department. That's not going to fly. It has to be a claim where they have been, or they feel that they have been impacted by a decision, either a promotion or hiring. So it has to be a very concrete example. Just because you celebrate Black History Month doesn't mean that someone is going to put a claim and win. And I'm just going to pass it over to you, Chris.
I think that's right. I mean, one way of thinking about risk, another way of putting what you said, Rosa, is that one way of thinking about risk is, where does the rubber meet the road, right? So, for Fortune 100 companies, they immediately have a target on their back. For huge law firms, it's the same thing. They're very easy targets. But for much smaller organizations, they don't. And so when it becomes a risk, is it could very well be, even though it hopefully it doesn't happen, it could very well be just with an angry employee, or somebody who was let go, somebody who wasn't promoted. And as a litigator, that's where I often see, over the years, but well before the admissions decision, where I've seen policies challenged. But in addition, and I'm mindful of the time here, in addition to thinking about what your mission is and being careful with how you're thinking about data, I think what this really boils down to is understanding what your policies and statements are. I mean, I think really taking a close look. We have the word audit here. I'm a lawyer, not an auditor, but I do think that taking a really close look at what you do and what you say about what you do is very, very important, and it should be with a critical eye. And preferably it would be with counsel, who can help guide you on what's okay and what isn't. But even if it isn't, I think even just from the benefit of this conversation, hopefully you might have a critical eye on on where you might be exposing yourself, where you don't want to be. So I think that's honestly the most important thing that you can do, as well as understand your own risk tolerance and sort of make this an iterative process. This should never be something that sits on a shelf, right? This should always be something that's revisited, which should be anyway, right? You should always be revisiting what your goals are, what your mission is. I mean, Rosa, as part on the DE&I committee at our firm, I remember putting together our initial DE&I mission statement, and we've revisited it multiple times. Yeah. And I think that's really important.
And we continue to do. I mean, our DE&I strategy, we have a 3-year kind of revamping goal, but every day we go back and check and say, does this make sense? Can we add this? Is this working? So it should be a journey, not a destination, and you should not be afraid of or hesitant to edit as you go and to make things more, how can I say this, more relevant to the work that you're doing right now at this moment. So best practices, Chris, what do you think?
So I think we've covered a lot.
Yeah, pretty much everything, right?
Yeah. So I think we've gone through it. Just to summarize, think about and take a look at how you're measuring, how you're articulating what your values are. Make sure that your initiatives serve a purpose and are not inescapably imponderable, in the words of the Supreme Court. Make sure you've got the right policies in place. And then I like this a lot. Make lessons from the military. History has shown that placing a diverse armed forces under the command of homogenous leadership is a recipe for internal resentment, discord, and violence. By contrast, units that are diverse across all levels are more cohesive, collaborative, and effective. And the reason that we highlight this is because that's a way of articulating the benefits and values that come out of DE&I programs. And if it seems that I'm flying through this, it's because I see the clock. Yes. So just on the last couple of slides, think about this as mission-based versus identity-based objectives. Think about what's mandatory versus what's voluntary. Making the programs, are programs closed, or are they open to all? There was a question in the Q&A about what happened with the law firms. Like, why was it okay? Why were the lawsuits dropped? It's because they made the diversity fellowships open to everybody. And dropped language about race in their public statements. Focus on inclusion. Focusing on inclusion in organizations is actually a really powerful tool as well, because it gets away from diversity metrics, but it allows the organization to articulate values that get to the same kinds of issues. Again, it's not perfect, but it does help. Think about holistically reviewing candidates based on their lived experience. Again, that's straight out of the admissions decision. And think about ways of enhancing recruitment and engagement. And I think we're at the end of our presentation. Sorry, we're a couple minutes over, but Beth, I think we're getting you back into the conversation.
I am here. At some point, I guess my picture will show up so you can hear my voice. So Rosa and Chris, thank you so much. This was really helpful. I'm going to ask just a couple questions because we have a ton of questions in the chat. And so my first question is, and I think you may have touched on this a little bit, but just trying to help people understand how did we get here, right? Because this is I think for folks that have been doing DE&I work for years, we have these ebbs and flows, and when there's pushback, but it seems like we are up against more pushback than we've had in a while. So how did we get here?
Rosa, you want me to take the first stab at that?
Yes, and then I can just add to
that. Beth, that's a fantastic question, and I say that because I'm partly not really sure how to answer it, because I think it's really complicated. I think that one of the things that's true about what we see in the law, the laws, I think, is always a lagging indicator, right? It's never, I shouldn't say never, but it's rarely a leading indicator. And for something like the admissions decision to get to the Supreme Court, that's years, if not decades, in the making, right? When I think about this in the more positive sense, if I think about, say, Brown v. Board, there are histories written about Brown versus Board of Education that where the NAACP, Thurgood Marshall, basically laid the groundwork for the decision over scores of legal decisions throughout the country. And I think that's very similar here. The New York Times piece that I was referring to, and if I can find the link, I'll put it in the chat, I think does a very good job of showing the similar efforts by conservative think tanks to really start to challenge this decision, and they got their huge victory. And I think partly that's one of the reasons why, for example, the Federalist Society has been working so hard for decades to have conservatives on the Supreme Court and in other courts, is to get to these kinds of decisions. So I really think what we're seeing now is the culmination of groundwork that's been laid for a long time, and it happens to come at a very polarized moment in politics. So I think that's I think how I see it. Rose, I don't know if you have anything to add to that.
No, 100%. So Beth, I've been doing this work since DEI was a hot topic, right? I started my career about 17 years ago at Accenture when they launched their global DEI department. And management consulting companies have always been at the forefront of DEI because they understood the war in talent. They understood, what they needed and how to approach the lack of talent in the US. So name it. Back in the days, we focused on women. We focused on women, moving women to leadership roles, right? That was what that diversity, equity, and inclusion was. And I think through the years, as our society has changed, our priorities have changed, our demographics have changed. We have expanded the definition of diversity. More organizations have seen the value, have focused on the work. And then 3-4 years ago, 3 years ago, George Floyd happened. This was a hot topic of conversation. And many right-wing activists saw how using diversity, equity, and inclusion work as a weapon of fear worked in the political landscape 4 years ago, 6 years ago. This is my personal opinion, just with that. When they saw that this could work to separate and create fear and disinformation, then an army was formed to combat DEI work, not only in legal and not only in higher education, but in schools, right? You see all the laws that were brought forth in, for example, in Florida, the Woke Act, and Don't Say Gay Act, and I mean, you name it act, right? All of this misinformation campaigns that are founded in fear and in isolation and polarization. So I think that 3 years ago, when the killing of George Floyd happened, where more and more organizations kind of jumped in and wanted to do something, it was a very traumatic event for those that didn't want to see DEI succeed. And this is how we got here right now, because they saw that if they used it as a weapon of misinformation, it would work.
Thank you both. That's really helpful and thought-provoking. I'm going to jump into the questions because we have a lot of them. So my first question, you touched on this a little bit. Could you provide some examples of how organizations can tie their DEIB goals to their mission and or create mission-driven programs? So what are some suggestions? And again, because Chris is a lawyer, he's just making recommendations. He's not telling you have to do this. This doesn't mean you can't be sued, even if he makes these suggestions. So I just want to make sure that folks are clear on that this doesn't mean, people can't come after you. People can always come after you. But what are some, examples of how folks can think about tying their goals to their mission?
Beth, thank you for giving the disclaimer that I did not. I appreciate it. But you're right, and we're not providing legal advice. But hopefully this gives you all good understanding. Rosa, do you want to start with this one, and then I'll chime in?
1,000%. So I would say, really thinking about why, again, go to your why. Why do you want to do this? Why do you care about diversity, equity, and inclusion? Do you care because it's good for business? Do you care because it is part of your DNA, the DNA of your organization? So think about why, and then break it down into achievable goals. Do you have currently, look at your workforce, look at your environment, assess your culture. Do you have an organization that is representative of where you want to be? Do you need to increase your workforce demographics, right? Do you need to increase your gender representation in leadership, for example, in order to be what you want to be in the organization that you want to be? Then you can have goals around that, but the goals have to be achievable and they have to be lawful. So if you are currently at, let me just give you a very severe example, 10% of your leadership are women and 90% are men. And you want to be, and you sell yourself as an organization that really truly values inclusivity and diversity and inclusion in whatever industry you're in. So you should be doing something to diversify your leadership ranks. What your plan is what matters. How you going to move that 10%, that needle forward, is what matters. Are you going to partner with external organizations? Are you going to have a pipeline program, a professional development program, a succession plan that will give access to more women the opportunity to apply to these roles? Are you going to make the requirements more gender neutral? I mean, think about what your goals are and why you're doing this, and then break it into bite-sized achievable goals. I'm also understanding that this is not a journey. This is not a destination, it's a journey. And you are going to make mistakes, Beth. You are going to fail in the process, and it's okay. Then you go back and you find another way of achieving your goals. But I think I will say, like, the main advice for me is to really understand why you want to do this. Understand where you are. Data is really important. And how you're going to get to where you want to be as an organization in a way that is lawful and that is achievable. And Chris, what do you think about that?
Well, I agree with everything you said, and I think I would add a couple of things. So first, I think it's important that, one of the answers to the question, Beth, I think is, you really have to think carefully about the specifics of the organization. What industry are you in? Who are you trying to serve? And how do you best serve those in your industry? And that's going to be very specific. I think that there are general ways, though, to think about policies and missions. And what we're talking about here is, when I say policies and missions, I make that distinction because policies tend to be internal documents that guide organizational decision making, and missions tend to be external and internal, but really external documents that tell others what you're about. And I think for both, one of the slides that I know will be available to folks, one of the slides I think breaks down some of the differences. So if you have, for example, a policy or a mission or both that talks about what I'll call identity-based characteristics of diversity for the organization, I think it's important to reconsider that and think about what the mission is, like Rosa was saying. And so thinking about things in a mission-driven way as opposed to an identity-driven way is going to be really important. Now, what that mission is going to depend on the organization. Right. But I think that's important. Another is making sure to be, I think, focusing on things like on inclusivity and engagement and community can be also ways of getting at really important ideas that can, if done right, also increase diversity. But I think that that what that means for the organization is going to be different. But you can see what you're doing in what I'm suggesting is trying to expand the language in a mission or in a policy, so that you can include those diversity goals, but not make it exclusively about diversity goals.
Right. So I have a question which is connected to that, and so I'll see what your answer is. So if we do a survey of our employees, and then we see around inclusion or engagement that there are statistical differences based on identities, can we as an organization then implement some strategies for those specific identities, because our data shows that there is, discrepancies?
So
does that make sense?
It does. So the answer is yes, up until you get to specific identities, right? I think that's where you increase your risk, right? So I think you can absolutely take a survey. You can absolutely look at the data. You can ask for demographic information in that data, self-identified demographic information. You can look at, how someone's experience in an organization might differ based on where they fall. But then I think the question is, like, what's the solution if you see a disparity, right? And I think one of the difficulties that we're now in or the situation we're now in is that you run a high risk when you create identity specific solutions, even if it's an identity specific problem, right? And so I think that it doesn't make it impossible, but it does mean that I think some thought has to be put into how do you change. Let's say it's a question of I'm trying to think of something common in organizations, like, I feel like I'm not getting as many professional development experiences in comparison to my peers. And you see in an organization that it is people of color who have that experience disproportionately, as opposed to white employees. I think there it's a high risk for an organization to then say we're going to specifically target our BIPOC employees to make sure that they're getting more experiences. I think rather what ends up happening, and I'm kind of making this up, but it's sort of based on real experience, rather it's then saying, maybe what we need to do is have, 2 or 3 people in management of the organization actually take a look every month at what the professional development is of our employees, and make sure that it's being spread out equitably. That gets at the same issue, not incredibly directly, but at least it tries to resolve the problem. Rosa, does that make sense to you?
Yes, it does. And yes, so Beth, we do DEI and engagement surveys here at Foley Hoag, right? Like many organizations. And we do see the disparities in experiences from one group to the other. What we try to do when we see, for example, people with disabilities feel that the workforce is not, or the workplace is not as accessible, right, as they would like to see, right? Let's say this is a very random example. What we try to do is take that information and then make it into policies and practices and adjustments that benefit everyone, thinking about giving them what they need, right? Thinking about equity, but not excluding someone with abilities, for example. We're just making the workforce more accessible for everyone, because now we have information that it wasn't. So when you identify those gaps, and then you think about solutions that will benefit even the majority group, but at the end of the day, it will benefit the most those marginalized communities that are the one voicing their concern because it impacts them.
Great, thank you. And another question around, does this rule apply to nonprofit or unpaid board members? Can boards recruit members of specific races and or identities?
It applies. And it's the same sort of difficulty, I think, or the same, I shouldn't say difficulty, same set of risks that arises. One of the things is, this is sort of an indirect way of thinking about it. So our law firm has a foundation, and it's a grant making foundation, and the grants have been historically provided to those organizations that are they're micro grants to nonprofits that are fighting discrimination in some way, or racial inequity in some way. And one of the criteria in the grant making is that the board composition reflect the mission of the organization. And so if, let's say, in the grant review process, we see that the board is, white males at the age of 60, then it's not that, you need to recruit more people of color or more women. This does not reflect the stated value of the organization. And so I think it's the same kind of solution, right? That if the, thinking about the mission of the organization, does your board recruitment for nonprofit and for-profit organizations alike, does your board recruitment reflect the values of the organization? So unfortunately, yes, it does apply, but it's the same kind of solution that you need to be considering. I see a very active chat, by the way. It's great to see people engaged. Beth, I should say, there are a lot of questions to choose from. So
there are many questions coming in. I mean, Beth, can you hear us?
Oh, I think Beth is frozen. Rosa,
yes.
One question that I see as well in the chat, and I'll sort of do this until we get Beth back.
Yes, let's do this.
So one of the questions it's come up a couple times in the chat, and I see it come up a few times with organizations, is how to think about affinity groups, right? Or employee relationship groups, whatever you want to call them. One of the questions that has come up, it's sort of a case study, is, well, does this mean that if somebody wanted to have a white male affinity group in an organization, that we have to allow it? I know what my answer is, but I'm curious to know how you would deal with that as a practitioner in an organization.
Okay, so I'm going to say this on my own. This is my own opinion. There is a white male affinity group every day. Right? Like, yes, let's be real. Humor. Yeah, it's right. Let's be real. But I mean, we will have to allow it, right, Chris? I mean, it is an affinity group. That's what it is. It's a group of people that share the same background and the same ideology and the same mentality and the same passion, and they want to come together. Now that you'll have organizations that will propose that, and people that want to join, I don't know, right? Because that's another question. But if the offer is there and people are willing to spearhead it and share it and do programming, by law right now, you can't say no if you have affinity groups that support other groups already established, right, Chris? And organizations. Now, what I would say, can I just say one thing, a best practice? The purpose, we all know, the purpose of affinity groups are to provide spaces for people that are few in organizations, right? Empower, promote inclusivity, talk about issues that are happening at the organization, share our ideas, share like how did I survive this? Give me some tools, am I crazy, right? What we've done in order to be inclusive and really think about the universal DEI concept is to we open it to allies, right? And if someone is not an ally, they're not going to join, right? So No one that does not care about your mission and goals of your affinity group is going to attend every single meeting, or that you should allow, right? Someone that is making a very uncomfortable situation at worst. But what we do is that some affinity groups, they have their core cohort meetings when they talk about sensitive topics. And then they have events and meetings and times that are open to the whole entire membership. So you can balance it like that too. And that way you're not excluding, but you're including when appropriate.
Yeah.
And now we have Beth back.
Hi, Beth. If I can just add to that. So you're right. From a legal perspective, yes, you have to allow it if you allow affinity groups generally, right? And I see a couple of comments in the chat. So does that mean you have to pay for it? Well, if you're paying for your other groups, they have budgets for, like at our firm, right? We have budgets for lunches and things like that, then yes. But it also has to be open to everybody. And we make sure that our affinity groups are open to everybody. And I saw a couple of comments as well about, well, it could actually be a very good opportunity for examination, reflection, and understanding. And we, in our firm, we have an allies group, which is not a white male affinity group, but it is a group that is quite consciously sort of responding to the need to for others to have spaces where they have not had spaces before, and to make sure that the people are being reflective. So the answer is yes, but look, it also has to align with the values of the organization. So not everything is permissible. If it's an affinity group that ends up being, or whose purpose is to challenge other affinity groups, or to challenge the idea of affinity groups, or to challenge the missions of the organization, you don't have to allow that, right? So I think that it is sort of a fine balance, but what you can tell is it behooves the organization to interrogate the reasons behind an organization like that being created, to make sure that it aligns with missions and values.
Hey, so Chris and Rosa, sorry that I went away. I have no idea what's happening with my Zoom, but
we're glad you're back.
I'm back, yay! So if this question was posed, I apologize. But there was a question that came up about, if as an organization we acknowledged or admitted that we engaged in discriminatory practices, could we then do DEI or affirmative action programs without worrying about getting, well, you can always get sued, but would that be fun? Like if we just said, yes, we have engaged in discriminatory practices, so now we are going to put in these programs.
If it is a remedial program, right? If it is meant specifically to respond to past discriminatory behavior explicitly, then yes. As long as it's sort of limited in that way, then yes. Now, I will say that organizations need to be careful about admitting that they've engaged in past discriminatory behavior, because that kind of admission may permit you more flexibility in creating DEI programs, but it could also create liability. So it's just something to keep in mind. But yes, the answer is yes.
Okay. And then there was a question on, could you comment on the idea of required learning experiences based on mission if they also have a race-based component?
So I'm thinking about this as like, let's say programming offered by the organization where you have a speaker come in, or in a law firm, it might be, trainings that are provided on certain specific behaviors in organizations or with clients. I take that to be the nature of the question.
The mandatory learning training. Yeah.
Rosa, what's your thought on this?
Yeah, so for example, at Foley Hoag, we do have mandatory D&I onboarding training. And it's not this is horrible, this is your fault, we're not guilting anyone, we're not punishing anyone. It is an introduction to the new employee or new associate to where our vision and missions are with regards to DE&I. this is an organization that values X, Y, and Z. You are going to come in and work with a very diverse workforce. We expect you to be respectful to your colleagues. We talk about anti-discrimination policies. We talk about inclusion, it's all about kind of leveling the playing field to the new incoming associate or employee, so they can understand from day one that we are an organization that takes this work really seriously, right? And that any kind of behavior that is demonstrates, back to Chris' point, anything against our values and mission is not going to be tolerated. So there's nothing wrong with that. Now, mandatory learning that requires someone to go as part of their job that is race-based or gender-based, it's a little bit more tricky, right, Chris? Like if it's a requirement, like if they have to do this as a requirement for.
Yes, well, it is, and I think part of it depends on, it is more or less has to be universally required. I mean, the truth is, it's much better if these sorts of things are voluntary as opposed to mandatory. But if they are mandatory, it really has to be for everyone and for the benefit of everyone, both in how it's presented as well as what's provided in the content. I do see the follow-up to this question, however, which is wanting to have a base of understanding of the history of education in the U.S. and race-based differences. And that is very interesting to me because unless you're in Florida, the idea of providing an education about our collective racial past, let's say, as long as it serves a goal that is commensurate with the mission of the organization, strikes me as within bounds. So I think that I guess one way of thinking about the answer to this question is it's unfortunate that we're in this position that we pretty much have to interrogate anything that touches race. But the truth is, that is, to my mind, a perfectly legitimate thing to do, to simply be providing facts, essentially, and a forum to understand facts and a forum for people to discuss facts. I think is again, other than a state-based law that is probably violates the First Amendment, against something like that, I think that that's well within bounds.
Great. So we had a ton of questions, but we are near time. So I want to ask you both to just answer one question pretty quickly, which is, how do you think about staying courageous during this time, and how might you encourage others to do the same? Because as you said, starting this off, that part of these lawsuits it's about a scare tactic. Right. And so how do we not let fear, how do we not let risk get in our way?
Yeah, I will say, as a D&I practitioner, we are at the front lines of these attacks, right, Beth? We're getting it from every single direction. And as long as you are in an organization that is truly committed to this work, that supports you, that is not cutting your budget, that is not, reducing your staff, that is kind of empowering you, I will tell you that the work is worth fighting for. There's a lot of people that are counting on you, that are counting on your organization to get it right and to continue to move the needle forward. It's never been easy work. It's harder now, but it's worth every single attack, every single headline, every single setback, because at the end of the day, it is work that values and benefits everyone, right? I will say stay true to why you're doing this. Sometimes we have to silence the haters. We have to continue to reinforce the value within our organizations, continuously communicate the benefits of DE&I, have champions, rely on those champions and the people that really want and trust and support your work as sources of energy, and to guide this very difficult work in your organizations. And at the end of the day, I mean, I think this should pass too. it's like everything, right? We're now in the height of these attacks and all this misinformation. But at the end of the day, D&I work, especially in the US, is not going away. It is the core of what we're doing. So just keep at it, stay focused, and remember that while you're doing this, that there's a lot of people that rely on you to fight the fight and to be the voice in the room when they're not in there.
I'll just add, because I can't disagree with anything you said. YW I'm very proud to be on the board of YW. It's a wonderful, wonderful organization, and I can't think of better advocates for DEI work. And looking at the chat and looking at the Q&A, there's clearly a community of people who are dedicated to this work. So if folks need to feel courageous or to be reminded of how to be courageous, just look at this community. And I think, let's help each other through.
All right. Well, Chris and Rosa, thank you again so much for your time and your thoughtful replies to a lot of the questions and just your thinking about this. Thank you to everyone who participated and all the YW staff that did everything to put this together and to host. And I just want to add a couple of words and you add on to what Chris said, that now's the time where we need support, where we need community. So do reach out to others. We do have community of practice. So if you're interested, I think we dropped a link into, or if we haven't, we will drop a link so you can see about our community of practice. If you want to be in a room with other professionals doing this work, getting support from one another, we have programs that can support you on this. Foley Hoag is also doing work in this area. So there are others that you can reach out to. We are doing a series on being courageous during this time. So please, if you haven't signed up for our newsletter, please do that. We'll be doing the series through at least through June. And again, thank you all for your time. Chris and Rosa, again, thank you so much. And I wish everybody a good rest of your morning.
Thank you.
Take care.
Thank you, Rosa.